Good morning. This is Rich Sierra with Business SOS. What common legal mistakes business owners make and how to avoid them. I'm the president of the Florida Small Business Legal Center here in Boca Raton, Florida. This is episode number 21 of Business SOS. Thank you for listening. Today, I want to go back to the topic of litigation. And what I want to talk today about is the unforced errors in litigations, but really costly client mistakes that are commonly made in the litigation process that can be avoided, but it could be devastating. And they're really mostly mistakes that the client makes that could really affect our ability of business lawyers to do our job, but also can affect the outcome of the case if it's not handled properly. And these are truly unforced and avoidable errors. And the reason I bring this up, and I've talked about this throughout some of my prior podcasts, but I wanted to bring it into one episode. So in the case that you are suing someone or you're being sued, this will be a good episode to kind of go over and say, okay, these are the things that I need to avoid to really help my attorney do his or her job, and also to really have a much better outcome or the probability to have a much better outcome by avoiding these types of unforced errors, as I'm calling them. So I have a number of them, I have 5 or 6, so we'll go through them this morning. We'll get right into it. One of the common mistakes that, and I've been doing this now for 19 years in business litigation, it's very common that when we have that initial consultation and we begin to get the facts in the case and begin to gather all the documents, as business lawyers, we know the law, but we do not know the facts initially. So you as the client, you know the facts better than we do. You know what happened in the case, you know the parties are, you know what transpired, from your perspective, the other party breached the contract, you know what emails were sent, you know what text messages were sent. We don't have that information because we're coming brand new to the case. We didn't have enough information to know that perhaps a breach took place. We also have enough information to know that you were sued if you're the recipient of a lawsuit. But we do not know everything that happened in the last 2 years, for example, with that individual, that entity. So we need your help. In fact, if, again, dating myself, you remember the movie Jerry Maguire said, "Help me, help you." So that's basically our theme. Help us, help you by providing us the information that we need. So a common mistake is that sometimes clients inadvertently, sometimes on purpose, they don't tell us everything. They tell us the story that they want us to hear, the story that they believe will help their case from their perspective to try to have a better outcome, or try to convince us, listen, I have all this evidence that we have the case proven, and it is a slam dunk, as I've heard many times throughout my practice. I think I want to bring a reality check here. There's no case that is a slam dunk. And I think we need to emphasize that, because in contract law and in business law, specifically contract law, there are a lot of defenses to, a lot of nuances to a contract litigation case. And a contract attorney who handles litigation would understand those nuances. You, as the business owner, will not know that unless you're also a business litigation attorney, which could happen, but it's very rare that you would actually have this type of in-depth knowledge at an expert level knowledge. You're running your business. This is not what you do every day. We do this every single day. So what I ask my clients is, tell me everything. Give me all the documents. I want to give me all the text. Highlight the ones that you believe that are important, but I want to know everything. I want to gather all that information, even if you feel that the information might not be as relevant, might not be as important. Tell us everything. If you feel that something that you did or said that perhaps it will not help your case, tell us as well. Tell us as well, because we will have strategies in how to address it and how to deal with it. And that's part of the whole strategy of the case. Just tell us everything. Don't hold back. And if initially you send all the information and you find something later on, as you will basically have to get this information for the other side to provide, provide to them, just say, hey, listen, I forgot to send you this information. Here it is. And that's fine. Just tell us everything right from the beginning, everything that you know. It'll make life a lot easier. It'll make life a lot easier for you and also for us. So don't hold back. And that's a mistake. I guess mistake number one is not disclosing everything about the case, not disclosing material information about the case, specific information that is negative to you, to your case. Just bring it on. Tell us. We can handle it. Another mistake, this would be mistake number two, throughout the litigation process, mistake number two will be not meeting discovery deadlines. And let me go into discovery. Okay, throughout the course of the litigation, you will be required to provide, most likely, what is discovery. It'll be interrogatories that you have to answer under oath. Will be requests for production of documents that you'll have to provide documents that are relevant to the case, and there's a list of documents the opposing counsel will draft and request from us to them, to him or her. And also requests for admissions, whether you admit or deny or have no knowledge, certain facts about the case that the other side is going to ask you to admit because it'll help their case. Most likely they will be denied, but that's a different conversation altogether. But usually in the state court, here we have 30 days to, when we receive that request, we have 30 days to respond. So I like to, in my practice, I like to have those ready in 20 days. So we have a specific system in terms of getting the information to the client, the request, setting up an appointment with our staff to begin to do those initial drafts of the documents, then perhaps to do a second draft and look through the list of documents that we need to basically provide, also the interrogatories, and then we go through a final draft, which I review with the client, with you, and then if it is approved, then we'll finalize it and submit it. But I don't like, and my preference is not to wait to the last minute to provide those documents and provide those answers. Simply becomes a bit more stressful. Then mistakes are made. So you have 30 days. Sometimes circumstances take place. You need to ask for a short extension just to kind of meet that deadline, and that is fine. Everybody requests that once in a while. But a mistake that I see clients making is that not cooperating with the attorney's office when documents are requested and or when interrogatories are sent to the client and say, we have 30 days. You look at it, 30 days. I have a month. I'm not worried about it. I'll get back to you. On the 29th day, I'll begin to answer these questions. What happens in that case is it creates a time crunch for the attorney. We have an obligation to the court to meet deadlines, an obligation to you as the client to meet deadlines as well. So think about when you go into school, you start preparing for a final exam, you know about it a month in advance or 2 months in advance, so you begin to cram for the exam the night before. You're not going to have the same results the night before as if you begin to prepare for that final exam, much in advance, time in advance. So same thing here. So we don't want to have a situation, and this is a mistake that happens very often. We try to emphasize, just listen, we're going to set up an appointment a week from now. We're going to spend an hour. We're going to talk about this to begin to narrow down all the questions that you have the answers. We'll begin to draft those. The documents you already have, begin to gather them. The questions you have, you're not really sure. We're going to put aside. We're going to address them later. So we begin to narrow down those questions in order for you to have a really complete document when it's produced to opposing counsel, so we don't have to do this again later on. So when the attorney asks you, listen, we need to make an appointment to answer these questions, just make yourself available. It is your case. You came to us for help. You came to the attorney for help. So just, okay, fine. How much time do you need? 1 hour? Okay, here's the time. I'm going to begin to answer some of these questions. The way we approach it is begin to answer them in your own words. You're not sure about a question, leave it blank, say, I'm not sure. And we'll begin to prepare those answers. So what happens when you don't cooperate The attorney then has to ask for an extension, which will cost you money because that's going to be time the attorney needs to request that to opposing counsel, maybe file a motion with the court, get an agreed order, but also it creates a situation that then everything becomes a pressure situation. You're not going to be as accurate and as precise in your answers as if you prepare in advance. So discovery, not meeting discovery deadlines, not cooperating with the attorney to provide a timely response. It's a common mistakes, and frankly, it is avoidable. It's simply a scheduling matter that there's no reason for it not to happen, but it does. And I know everybody's busy, but it is your case at the end of the day. It's not our case. Sometimes and this goes in the same theme of lack of cooperation, is that sometimes we need to make an appointment to talk to you, to give you an update in the case, or because we have a question, or because we're preparing an answer to some type of pleading and we want to basically talk to you because it's important. Then if you're not available to talk to us when we request it, then it delays the process for us to be able to provide services to you. And then we move on to something else, then we try to reschedule again, or we don't hear from you. So, my policy is that I like to have a response within one business day when we request it, so that way we can, within that particular work week, we can go ahead and address particular issue, and then we can move on and continue advancing your case. So if you get a call from your attorney, an email for the most part, or a text from your attorney's office, most likely a paralegal, the assistant is going to be requesting this, just say, okay, listen, when are you available? Here. Okay, let's go ahead and do it. How much time you need? 15 minutes, 20 minutes? And things can move faster. So that's another enforced error. Mistake number 3, I want to talk about depositions in this particular, in this mistake. Depositions are part of discovery. So a deposition, basically, if your deposition is going to be taken, and I can have a whole series, a whole episode on preparing for a deposition, you're going to be asked questions under oath. Your attorney really has very little control of what will happen at that deposition. The attorney cannot coach you. The attorney he can only object to what we call form or privilege, and that's more technical. But the bottom line is you have to address the deposition as if you were testifying in court. So attorney is basically almost helpless to the extent that you're not going to have assistance. But what the attorney can do is prepare you beforehand so you know what to expect at that deposition, so you're prepared properly. So mistake number 4, mistake number 4 in this case, let me see, discovery deadlines, not disclosing information, not meeting discovery deadlines, not cooperating, timely response. Okay, this will be number 4. Not preparing for a deposition. So if your deposition will be scheduled, say 2 months from now, your attorney should set up a time, maybe 2 days before or 3 days before, to prepare you for a deposition and to explain to you what a deposition is, what facts will be coming out, what likely questions you will have, and you will have that conversation with the attorney to know what to expect. So if your attorney asks you, listen, we need to have a meeting to prepare for this depo, make yourself available. And I like to do it a few days beforehand, so not the day before, simply because anything can happen the day before, that some emergency can happen, some unexpected issue can happen, that appointment is not made, then you're going in that deposition blind. So, and that's not a good idea. So if they ask you for the time, make yourself available. Again, it is your case. It is to help you. And the more prepared you're in that deposition, the better, most likely outcome you will have. You will have the right answers that you will be producing. At the same time, you will be more relaxed because it's an intimidating process. The opposing counsels objective in a deposition is to gather evidence through your sworn testimony to use against you in your case. So the more relaxed you are in that deposition, more confident you are, the better you will be. So preparation is key. I will also use the same thing on the same theme with the mediation. And I've talked in prior episodes about mediation, and I'm a big proponent of that. And I love mediation simply because you can be very creative, and it gives really you the opportunity to resolve the case in your own terms. So mediation preparation is just as important. So my policy is that before a mediation, we always have a pre-mediation, at least a 1-hour meeting, and we'll go over the mediation strategies, tactics, the facts, how we're going to address the mediation, and really preparing for the mediation as well is extremely important. So if your attorney wants to have a meeting with you to prepare for the mediation, make yourself available. It is your case. And my experience has been the more prepared you are for a mediation, the better outcome you will have at that mediation. So again, it's about making yourself available for the attorney when it is requested. And a mistake that I see, people sometimes are too busy, say, I don't want to deal with this. You handle it. No, it is your case. You know the facts. And sometimes you bring out facts that we were not aware of, or perhaps we overlook. We're human. Sometimes all those documents are presented to us. We can review them, but we did not type the text message. We did not send the text message. We're looking at it from the perspective of looking at evidence, looking at what was said, what admissions were made. You can identify those documents or those emails from the perspective of your experience. You received those documents, you sent the email, you received it, you know the context and where that communication took place, and you can tell us, I remember that particular email that was sent on this particular day, the other side admitted to the following. We can look that up and said, okay, you're right, I'm going to bring this up. But again, you know the facts, we know the law. So the more information you provide to us, the better. And preparation is key in every aspect of litigation. And your availability and your cooperation is essential to have the probability of a better outcome. Mistake number 6, and this happens very often. Unfortunately, it does happen. And now with dealing with a lot of communication via Zoom, it's not in person. And I know this is very emotional. Litigation is a very emotional process. And sometimes clients get very angry at opposing counsel. They get very angry at what the questions that they're asking, the allegations made in the complaint, and they become very combative in a deposition. They become very argumentative on a deposition. And what happens, and even in the mediation as well. So what happens in this case is when you begin to spar with the attorney on the other side is human, opposing counsel is human being too, and the emotions are gonna begin to rise. So the way my position is a civil matter. It's a business dispute. Yes, it is important. It is emotional, but to the extent that we can maintain a level of professionalism and civility, it is better for everyone. So becoming combative with opposing counsel, calling names, it's just not a good idea, simply because it just clouds the issue, and it makes it very difficult for the attorney, because at some point this is the conversation of settlement is going to take place. At some point. In my experience, people don't settle when they're pissed off. Okay? So if you're going to basically get the opposing counsel angry because you start accusing, making names and getting in a combative situation, it makes my job or the job of the attorney more difficult and try to work out some type of settlement to get the issue resolved. So the case is not about the lawyer. The case is about the client he or she is representing. So we need to set emotions aside, deal with the facts, And nothing positive is going to it's going to be, there's nothing positive that's going to come out of by engaging in a combative situation with opposing counsel. They're professionals, they're doing their job, everybody has their style. In my experience, cases settle faster when opposing counsel, both attorneys for both sides, have a professional and civil and cordial relationship. And we leave emotions aside. We do our job. We represent our clients. We do our job with the facts and the law. But name calling, combative, is not going to help you. So just, if you need to take a break, take it. You need to say, do I need to be in Zoom for how long? Get off the Zoom call. But just do not add more fuel to the fire. And this goes for mediation as well. Mediation, everybody's in a Zoom call, and or if you're in the same conference room, again, keep your emotions in check and do not get opposing counsel angry. This also goes sometimes with the judge. Doesn't happen very often, but sometimes you have an evidentiary hearing in which you have to testify in front of the judge. And your demeanor in front of the judge is extremely important. And, getting combative with the judge, argumentative with the judge, is not a good idea. Level of professionalism, a level of civility is key here, but antagonizing the judge is never a good idea, and it clouds the case. It could cloud the issue, meaning that judge is going to remember you for the entire case. And I prefer for the judge not to remember you for anything. So you don't want that judge, when he has 2,000, 3,000 cases, for you to show up and say, I remember you. You're the one that basically argued with me. So that's going to be difficult. So again, don't argue with opposing counsel. Do not argue with the judge. Let the attorneys handle that. We'll deal with it. We have rules of professional conduct. We know what to do. We know what to say. We're here to help you, but just don't get in the ring. It's not going to be good for you. Mistake number 7, and I'm going to end with this one, is that, and this is like a two-part mistake. Number 1, you get sued, and obviously you're angry, and the allegations there, they're inflammatory, the breach of contract, they say you committed fraud, et cetera, et cetera. They're always the same, okay? But you're understandably angry. So what you want to do, basically get into your PC, your laptop, and start drafting this letter and immediately send it to the judge, you send it to opposing counsel, you file an answer to a lawsuit. Okay? You file it. And then you basically, after you file it, you basically decide to call a lawyer. All right, so what you did there is a fatal mistake, could be a fatal mistake. Because in contract law, when you decide to file a response to a lawsuit, you waive a ton of defenses that could have been raised if you did not file that document in the first place. And I see that happening very often, that people do their answers. They have 20 days for the most part. They have 20 days in Florida, so I don't know why people get so hurry about this. It's basically they're angry. So if you get sued, take a deep breath. You have 20 days. Relax. Call an attorney. That's it. Just call an attorney and don't do any harm. Don't go ahead and harm your case by filing some type of response with the lawsuit to the courthouse, which can be construed as an answer, and then you waive defenses. Clearly, we have ways to fix it, but it's going to cost you more money because we need to undo what you did in the first place. Another mistake that I see attorneys make is that they receive this lawsuit and they begin to negotiate with the attorney who sued you in the first place. And they begin to provide documents to the attorney just voluntarily. Oh, he asked me for financial records. Let me just send it to him. They begin to negotiate terms of settlement with the attorney after the lawsuit has been filed. Okay? You cannot do that. It's not a good idea. for a number of reasons. Number one, you're already outmatched. You're dealing with a professional who knows the rules of courts. You don't. Number two, you're such in a disadvantage that you might be volunteering information that otherwise you didn't have to volunteer. The attorney's job is to get information from you to win the case. So he's not your friend. He's there to do his or her job. He's ready to sue you to get some relief. So you're negotiating directly with the attorney. You're at a tremendous disadvantage. Okay, you don't go into an MMA fight with a professional fighter knowing you're going to get beat. It's just not a good idea. So the same thing here. Somebody's suing you. They're a professional. They know what they're doing. You don't. Just don't go there. You take a deep breath. Get an attorney. If they contact you first, which has happened, I sued you. Let's negotiate this. You say, you know what? No, I'm going to be talking to an attorney. I'm going to retain an attorney. My attorney will contact you. Thank you. Do not negotiate with opposing counsel. So for today, that's, in terms of recapping, disclose everything to your lawyer. It's very important. Tell us everything, the good, the bad, and the ugly. Meet discovery deadlines. It is important that we meet those deadlines, but cooperate with your lawyer to provide you to be able to prepare for those answers. Cooperate with the attorney when he or she asks you for a time to speak, most likely be over the phone or via Zoom. Prepare for a deposition and prepare for a mediation. Extremely important to do that. Do not be combative with the judge or opposing counsel. It doesn't help. It's not going to help your case. And also, do not answer your own lawsuit, and do not negotiate directly with opposing counsel. Get an attorney to help you do this. So that's a recap for episode 21. If you want to reach me, you can reach me at richsierra.com. Again, it's richsierra.com. And if you send me a legal question, if I select your legal question and answer in the show, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble, and you can ask for your local bookstores. And I'll go over some of the items that I talked today in the book. You want to learn more about our legal services, you can reach us at floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. If you want to reach me, we're 866-842-5202. If you like the podcast, please follow us and give us a review. You can share it with other business owners. And also the algorithms begin to suggest the show to other business owners. I think we're providing valuable information for you. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.